Hi, let's move to Title 13 on Special Corporation. So, nagbihis ako because if I may just shamelessly plug, it's Family Day. So, I took a picture of my family behind me. Okay. Now, let's move on to educational corporations. Actually, it's relatively self-explanatory. Section 105 talks about the incorporation. Section 106 maintained the 5 to 15 requirement on the number of the Board of Trustees. The difference would be that it should be in multiples of 5. Also, there is what we call staggered terms for members of the board, where one-fifth of the number shall expire every year. This is so that the operations of educational corporations continue. They will not be any operation will not be hampered by the fact that there is a lack of quorum in the members of the board. Just please read it on your own. I just want to add that when you talk about special laws when it comes to educational corporations, as mentioned in Section 105, what would govern would be Batas Pambansa bilang 232 as amended by RR 7798 or the Education Act of 1982, in which I am thankful to say you and I were both not yet born at that time. So section let's see. When you talk about educational corporation, Section 45 of the Revised Corporation Code still governs, where it must, an incorporation of an educational corporation must be accompanied by a certificate of the appropriate government agency to the effect that the bylaws or amendments are in accordance with the law. Also, the same favorable recommendation is required in instances where educational institutions were to undergo mergers or consolidations, if you remember, under Section 78. Lastly, please note that educational institutions cannot be organized as closed corporations, and this is expressly stated under Section 95. So under Section 106, if you read it, let me just put it here. If you notice under second paragraph, unless otherwise provided in the articles or bylaws, the Board of Trustees of incorporated schools shall have a term of office where one-fifth of their number shall expire every year. That does not mean that this can be foregone in the articles of incorporation. That portion on staggered system of for the Board of Trustees is mandatory. What the provision meant by unless otherwise provided in the articles is that there is now an option to provide for a different percentage of staggered term. Not that it can provide for a fixed term. So, to rule otherwise would actually defeat the first paragraph where the number of trustees shall be in multiples of 5. Although there is an opinion by the SEC that stated that it can be possible where instead of 5 years, the bylaws of an educational corporation may provide for a term of 2 years. And any director who continues to serve after such 2-year term is only occupying the office in a holdover capacity. That was actually upheld in an SEC opinion. If you remember what I mentioned in a previous video about foreigners being able to form part of non-stock corporations, when it comes to educational institutions, foreigners are not allowed to become members. And this can be seen under the Constitution as implemented in PD 176. In an SEC opinion, they said that neither can a foreigner be elected as chairman. Obviously, if they cannot be members, then they cannot be members of the board and they cannot be a chairperson as well. I will not anymore mention parts of the law because I don't think you need to know that. So when you talk about educational institutions and the nationality requirement, please note that the requirement applies to natural-born citizens who have lost their citizenship by acquiring naturalized citizenship, say in America. If that's the case, then they cannot be members anymore. And the rule requiring Filipinos to own, it applies to online tutorial schools that issue certificates of trainings or diplomas because they are considered educational institutions. That's actually relevant now, especially since everything is online. For chapter 2, I'll continue with religious corporations. So section 107, hold on. Okay. If you read chapter 2, it talks about three kinds of religious denominations, sects, or churches that can acquire legal personality. One is a corporation sole, and this is found under sections 108 to 113. Two, a corporation aggregate, or what we call a religious society, and this is under section 114. And three, an ordinary non-stock religious corporation under sections 86 to 94, and we've already discussed this earlier. What do you need to know when it comes to religious corporations? Section 108 is a corporation sole. In this case, please note that, let's see, the chief archbishop, bishop, priest, minister, rabbi, or other presiding elder just holds the property as a trustee. So this is different from a one-person corporation where the that single stockholder is not a trustee in that sense, no. They are much like any other stockholder. Why is this important? Because in a Supreme Court case where there was a church who purchased or was donated property, the trustee kept on changing from a Filipino to a foreigner. At the time that the case was filed, the trustee or the chief archbishop was a Canadian citizen. So they were questioning the donation of property to that church. The Supreme Court allowed the church to acquire the property by donation. It emphasized there that bishops or archbishops are merely administrators of the church properties that come to their possession and which they hold in trust for the church. Moreover, the members of the Roman Catholic Apostolic faith in that case were within the territory of Davao, were actually predominantly Filipino citizens. So there was no constitutional violation. If you remember, I mentioned in a previous video, it is against the constitution for foreigners to hold land. So in that case, the Roman Catholic Apostolic faith was considered a Filipino domestic corporation rather. So just read on your own the articles on the religious corporations as it's relatively self-explanatory. A religious denomination which does not want to acquire juridical personality separate and distinct from its members need not register with the SEC. So to be clear, even if there are provisions under the revised corporation code for religious corporations, the RCCP does not require any religious group to be registered. The registration is only for purposes of having a separate juridical personality. What else is unique about a corporation sole? Unlike regular corporations governed by Section 45, bylaws are not necessary. Why? Because, if you remember, bylaws are rules on how to regulate the internal affairs. And when you talk about corporation soles, like for Roman Catholics out there, they are usually governed by their own canons. So, the state cannot meddle in purely ecclesiastical affairs. Religious corporations are subject to the jurisdiction of the SEC only in terms of what is legal and corporate. So, for example, courts can take cognizance of cases involving the validity of disaffiliation of a member. So what are ecclesiastical affairs that the SEC cannot meddle with? These are matters that concern creed, doctrine, form of worship of the church, adoption and enforcement within a religious association of laws and regulations for the government of membership, the power of excluding from such associations deemed unworthy of membership. Yan. So, basically, these involve relationship between the church and its members and relate to matters of faith. Okay? So, the state cannot meddle when we are talking about excommunication, ordinations of religious ministers, administration of sacraments, and other activities attached with religious significance. When we talk about a religious corporation, they may opt for a fixed term in the Articles of Incorporation. After the expiration of the term of the articles, they are deemed legally dissolved. So in that sense, what is the general rule on corporations as regards the perpetual existence and the option to choose a limited life is still applicable to religious corporations. One last. When it comes to conversions into a corporation aggregate, from a corporation sale to a corporation aggregate, it is possible, and the only thing that is needed to be done is an amendment of the Articles of Incorporation. So the Supreme Court explained that although a non-stock corporation has a personality that is distinct from the members, the articles cannot be amended solely through the action of the board. The amendment needs the concurrence of at least 2/3 of its membership because you are already amending the articles. So if such approval mechanism is made to operate in a corporation sole, its one member needs to get the concurrence of 2/3 of its membership. So it's not just on his or her own. Why? Because again, I will repeat, the chief archbishop, priest, minister, rabbi, or other presiding elder is just a trustee. Chapter 3, One-Person Corporation. So this is a very important part of the Revised Corporation Code because it's actually one of the main differences between this and the previous Corporation Code. Now, a natural person can actually form a corporation. If you look at it, Section 116, let me just clarify an important point here. It talks about a natural person. However, when you look at the word trust or estate, it's actually the wrong use of a term because a trust does not have a separate juridical personality. A trust is actually an agreement, and an estate is the congregation of the decedent's property. So what Section 116 actually refers to is a trustee. So a trustee must be a natural person. Therefore, a bank acting as a trustee cannot form a one-person corporation. When you talk about estates, therefore, we are talking about an administrator or an administratrix for a female, an executor or an executrix, and a guardian or a conservator. They must be natural persons as well. The second paragraph talks about who cannot form a one-person corporation. And, if I may continue, a natural person cannot form a one-person corporation for the exercise of a profession. Please note that there is an exception for those provided under special laws. If you would like to refer to the one of my previous videos, I have enumerated there the types of the types of professions that can actually form a corporation, such as architecture. Yeah, that's one that I remember. So when it comes to sections 115 and 116, if you please also note that when you talk about trust, it does not include trust entities such as trust companies because these are regulated by the Bangko Sentral. If you look at the definition under 115 and 116, sorry, nadidisturb ako sa kaputian ko, pero please forgive me, this is the only time I'm ever this white. One natural person can actually form more than one OPC. So for example, me, I can form more than one. And this is actually, I don't know if the legislators actually thought of this, but it can actually be a venue for wealthy people to use this as a method of tax avoidance, not evasion, because it's not prohibited for a natural person to form more than one OPC. Even foreign nationals can form an OPC as long as the business or the purpose of the OPC is not limited, or it is not an investment area that is reserved for Filipinos. When we talk about Section 117, there is no minimum capital stock required unless it is required by special law. This is to encourage small and medium enterprises to use the corporate vehicle as a way to start their business. Now, how about foreign nationals? Please note that under the Retail Trade Liberalization Act, or RA 8762, there are particular minimum capitalization requirements for foreign nationals. I will not anymore discuss how much or what types of investments these are. When we talk about articles of incorporation, please note that there is substantial compliance allowed, and this is on top of the requirements of the articles that is stated under SEC. Where will I write it here? SEC Memorandum Circular Number 7, Series of 2019. It actually gave a particular form for articles of incorporation of OPCs. You don't need to look into it really, because most of the provisions there in the SEC Memorandum Circular are really just implementations of this chapter, Chapter 3. So when it comes to bylaws, there is no need to submit a bylaws. Why? Because the OPC is handled by one person. And what is the bylaw? What are the bylaws for? These are rules governing the conduct of internal affairs. Of course, there's no need to create your own rule because you're only one person, right? And Section 120, the display of corporate name, states that the letters OPC must be either below or at the end. So it cannot be OPC, say, J Corporation. Okay? What else do you need to know? If you've noticed, under Title 13, Chapter 3 on OPCs, there may be administrative sanctions given by the SEC for failure to comply with certain requirements under this chapter, but there are no legal commercial consequences. So, there is no liability under Section 161 for failure to comply with the requirements stated in this chapter. So, the SEC rules provide that the term of existence of the OPC shall be perpetual. What happens? It's an OPC, there's only one person, and a person's life is not for eternity. That is why there is a need to that's why there's a need to appoint nominees and an alternate nominee. Let's see. Oh, before we go into that, let's go to Section 121. A single stockholder shall be the sole director and president. So when it comes to the president, there's no choice, it's that person. But when it comes to treasurers, corporate secretaries, and other officers, the stockholder can actually appoint them. And they must notify the SEC within 5 days from appointment. So, it is possible also that the single stockholder will be the treasurer and other officer. What is not allowed is for that stockholder to be the corporate secretary. What if that single stockholder is the treasurer? Then he or she must give a bond. And usually this bond would depend on how much the capitalization of the OPC is. it's usually pegged at the authorized capital stock from 1 to 5 million. Ganyan. So if the authorized capital stock is a million, the surety bond coverage is also around a million. Mm, Although the life of an OPC is perpetual, there is an exception, and that is if the OPC is run by a trustee or the administrator of an estate. In those cases, the life of the OPC is coterminous with the existence of the trust or the estate. Why? Because usually the OPC is incorporated for purposes of administering the trust or the estate. So, pag wala na yung estate or trust, there's no more reason to continue with that OPC. Just note the periods under sections 122 and 123. I will not clarify or talk about it anymore. So the bond that is required for a self-appointed treasurer is a continuing requirement so long as he or she is the treasurer. Once he or she appoints another one, then they can actually have the bond revoked or canceled, rather. So when I was talking about the nominees and alternate nominees, this is covered by section 124. And here it states that their names must be in the articles of incorporation and the extent and limitations of their authority. So the written consent of the nominee here under the third paragraph shall be secured or attached to the application. However, please note that what is required is written consent. It is not required for the nominee or the alternate nominee to sign the articles of incorporation. It can be in a separate document. So what is the term of the nominee or the alternate? It would depend on the type of vacancy of that single stockholder. If the vacancy is temporary, meaning they are just incapacitated, say they are sick or they cannot perform their functions or they are abroad and they cannot tend to the business, then the term is just temporary for us until that single stockholder regains the capacity to assume duties. So it would depend on the circumstance of the case, no? But if it's a permanent incapacity or the single stockholder dies, then the nominee sits until the legal heirs have been determined and the heirs have designated one of them or have agreed that the administrator shall be the single stockholder. So please note, it's not the estate. We're talking about administrator, executor, conservator. Yan. The reason why they just put estate siguro is for to make the provision relatively short. It would be difficult to enumerate each one. Why? Because when you talk about estates, you are not just limited to administrator, executor, conservator, ganyan. There are different nomenclatures when it comes to the person who is entitled to or who is appointed by the court to manage the affairs of the estate. You can change the nominee or alternate nominee at any time. The only requirement is that the single stockholder must submit the name. So, please note that the articles need not be amended even if the names of the original nominee was stated therein. Let's talk about the corporate books of an OPC. Here, they shall maintain a minutes book and there is no more need for meetings. It's kind of silly because that person would hold a meeting by himself or herself. That's why you only need to have a record. And this is for easy reference, no? What is required is a written resolution. But this does not prevent a single person from having his own meeting. If he or she wants to hold a recorded meeting, bahala siya. Up to him. So there are particular repertorial requirements for OPCs and these are stated under section 129. Please read them on your own. Now, failure to comply with Section 129 will subject the single stockholder to the liabilities under Section 161. This is because Section 161 particularly states that persons who fail to comply with any repertory requirement under the revised corporation code are liable under 161. Section 130. Now this is well, for lack of a better term, this is actually a strange provision. Why? Because in this case, the liability of a single stockholder is limited, but that single stockholder has the burden of proving that one, the corporation was adequately financed. Dean Villanueva now interprets the word was as the single stockholder must prove it was adequately financed at the point of incorporation only. That single stockholder need not prove that the corporation was adequately financed all throughout the operation of the OPC. There is a second type of proof that the single stockholder must prove, and that is, meaning it's continuing, that the property of the OPC is always independent of the stockholder's personal property. Otherwise, the liability of the single stockholder is joint with the OPC. So this is actually a commercially disadvantageous feature of the OPC. Lastly, when it comes to conversion, there are two types, Section 132 and 131. 131 talks about an ordinary corporation becoming an OPC. In that case, what is required is an application for conversion, coupled with the submission of requirements that the SEC will enumerate. Therefore, in this case, what is required is the approval of the SEC, which is evidenced by a certificate. Okay. It is only upon approval that the ordinary corporation will become an OPC. On the other hand, if you're talking about a conversion from an OPC to an ordinary corporation, what is only required is due notice and compliance with all the requirements under an ordinary corporation. So, it must be filed within 60 days leading to the conversion. So, in that case, the commission will also issue a certificate. But if you look at the provision, you don't need approval anymore. The SEC will only issue a certificate after it gets the due notice and it complies with the requirements. Here kasi under Section 131, it would seem like the SEC has discretion. So an ordinary corporation is not deemed dissolved if it is converted into an OPC. The legal personality continues, and the single stockholder will be responsible for the ordinary corporation's outstanding liabilities. So why are there instances where an OPC may want to convert into an ordinary corporation? This may happen if the OPC becomes bigger and the single stockholder can no longer perform the functions by him or herself. Or the business can become more complex and time-consuming. Or simply, the single stockholder may want to raise additional funds from other persons. So that covers Title 13 on special corporations.